Ready? Start. The present petition has been filed under Article 227 of the Constitution of India, laying challenge to the legality and validity of the order dated 28/1/2026 passed by the Court of the Additional District Judge, Court number 5, Hathras in SCC Revision number 31 of 2020, whereby the revisional court has allowed the revision, set aside the order dated 27/8/2020 passed by the civil judge, senior division, Sadabad, district Hathras in miscellaneous case number 1 of 2020, and directed the trial court to register the proposed small causes court suit and proceed with the matter after issuing notice to the opposite party. Stopper. The plaint was presented before the Court of Civil Judge, Senior Division, Sadabad, district Hathras on 29/5/2020. Stop. Upon presentation of the plaint, the trial court observed that the plaintiff, namely Devkinandan Agrawal, claiming himself to be the managing trustee of the trust, had not clearly specified the basis on which he had been appointed as trustee or how he was authorized to institute the suit on behalf of the trust. Stop. On this premise, the trial court did not register the case as a small causes court suit, but instead treated the plaint as a miscellaneous matter and registered it as miscellaneous case number 1 or 2020. Stop. The trial court further directed the plaintiff to produce evidence regarding his authority to institute the proceedings on behalf of the trust. Stopper. Thereafter, the trial court proceeded to hear the plaintiff on the question of admission of the case. Stop. During the course of such proceedings, the trial court examined certain documents which were produced by the plaintiff, including the trust deed dated 9/9/1941, certain meeting agenda dated 7/9/1971, and minutes of the meeting. Stop. Upon examining those documents, the trial court came to the conclusion that Devkinandan Agrawal was not a party to the original suit trust deed, and that the documents relied upon by him did not satisfactorily establish his appointment as managing trustee or his authority to institute the suit on behalf of the trust. Stop. On that basis, the trial court, by order dated 27/8/2020, dismissed the case at the stage of admission itself, holding that the plaintiff had failed to establish his authority to manage the trust and therefore had no right to institute the suit. Stopper. Aggrieved by the aforesaid order, the plaintiff preferred SCC Revision number 31 of 2020 under section 25 of the Provincial Small Causes Courts Act before the Court of Additional District Judge, Court number 5, Hathras. Stop. In the revision, it was contended that the trial court had committed a manifest error of law in questioning the authority of the managing trustee at the stage of filing of the suit and in treating the plaint as a miscellaneous application instead of registering it as a small causes court suit. Stop. It was argued that the trial court had no jurisdiction to examine the internal management of the trust or the authority of the managing trustee at the stage of institution of the suit, particularly when the defendant had not yet been put to notice and had not raised any objection regarding the status of the plaintiff